Welcome to the Fifth Circuit. I feel like I'm a stranger here. I haven't been in the building for over a year until yesterday, but good to have people back here and safely handling continuing effects of the pandemic. We have 3 cases this morning. The usual rules apply with the adjustments of where you have to stand. What I expect we'll do is go straight through on all 3 cases, but we will see. First case of the day, Billy Spears versus Stephen McCraw. Mr. Clevenger.
Morning, Your Honor, and appreciate the opportunity to speak on behalf of Mr. Spears, and also appreciate the excuse to get out of New York. And wanted to start off by mentioning something that I mentioned in the brief, and that was, I wish I could bring you some lofty legal principles today. I don't think we have that in this case. I think this case is somewhat fact-dependent, and it comes down to a 12b6 issue, and that is, are the pleadings going to be construed in a light most favorable to the plaintiff, in this case, my client, Mr. Spears. Since it is fact-dependent, I'll back up a little bit and give you the history. In 2015, my client was working at the South by Southwest conference in Austin as security. He's a state trooper. The rapper Snoop Dogg, or actually his PR assistant, asked my client if they could have a photograph. My client had his photograph made with Snoop Dogg. It made the media. The director of DPS was upset about it. An email later emerged that my client allowed himself to be photographed with a dope-smoking cop hater. And then there was a separate and unrelated incident, and that was that my client off-duty had an encounter with an officer from another agency, and he reported that officer for misconduct. The other agency then turned around and reported it on my client. And so there were allegations of retaliation. Spears 1 was filed back at that time. It was later dismissed because my predecessor on that case failed to brief qualified immunity, but it was ultimately dismissed without prejudice. In this case, while Spears 1 was still pending, there began another series of retaliatory events, of one of which was that, actually this was not retaliatory, but my client had a pre-existing knee injury, was unable to work. The agency put him on medical leave because of this this knee injury, and the DPS, state police, without ever telling him, wanted him to take and pass a physical fitness test, which they had never before imposed on an officer who was on medical leave because of an injury. So contrary to their own policy, and for the first time in the history of the agency, they expect my client to take and pass a physical fitness test even though he cannot work because he has a knee injury. Worse, they never told my client that they were expecting him to take this test. But the most egregious, what makes this case really stand out is, as you've seen from the pleadings, at one point a senior commander, a major in the DPS, tampers with records, alters dates to make it appear that my client did not get his medical request forms in on time. That is not just some bald paper allegation and a complaint. The local district attorney looked at it. He referred it to the AG. It's now in front of the Dallas County District Attorney's Office. But we have a senior commander who's gone to some pretty considerable lengths to cause my client to have an untimely application for medical leave. As a result, he was put on what's called a performance improvement plan, which is a disciplinary matter. It stays in his file. It counts against him. And the lower court, basically the magistrate primarily, kind of cast this aside and said, well, the issue is your client did not pass a previous physical fitness test with high enough scores. The problem is that's completely contrary to DPS policy. As we've set forth in the complaint, That's never, ever happened before in DPS. He had a passing grade the time before, and essentially this same commander wanted to change the rules after the fact and say, well, I really did this to you because you didn't pass with a higher score.
Counsel, thanks for this review of the factual setting. Why don't we look at some of the issues that are being raised here? What is the significance to your case of the pleadings that the district court said could not be incorporated by preference? How much impact does that have? Is that even in your view? I mean, just start there, but then move through the other issues. Does that really help alter the case that we have before us, that you didn't get those pleadings considered?
Sure, I don't think it completely undermines the case. The incorporated pleadings certainly add a lot more detail that we would like to have included. We referenced them in our complaint.
And a lot of those details, the details about what happened leading up to Spears 1?
Right, exactly.
And those are not restated in your second complaint?
That is correct. Some of those details are not restated. The issue there, Your Honor, is the case law of this court does express some skepticism towards incorporated pleadings, no question. But it's not, there are other cases that leave open the door that it is an option. It appears to be a discretionary issue for the district court. The problem here is we already had 2 previous complaints that incorporated these pleadings. Nothing was said, no objections, they were considered. And then the third time, when we filed the second amended complaint, there was a new defendant involved who did object to the incorporated pleadings, and now all of a sudden they were disregarded and we were not given an opportunity to amend. So our position is at the very least that was an abuse of discretion. If you're going to allow two different complaints with incorporated pleadings and then belatedly say, nope, we changed our mind and you can't amend, that's very prejudicial to my client.
Okay. Well, the case is probably not going to turn on that. The case is probably not going to turn on the incorporation. Yes. Why don't you move on from that? Yes,
certainly. In one of the cases that we cited in the brief, Mooney versus Lafayette City School District, points out, and I think this is well established, that we only need to show a plausible basis for retaliation. I think we've done that in spades, and in fact, I'll go a step further. I think we have shown that the only plausible interpretation here is retaliation. Just ask yourself this question. What would cause a high-ranking law enforcement officer to commit a crime against one of his subordinates by tampering with a government record, forging signatures, forging dates? Something has to motivate that kind of criminal behavior against my client. And I asked this question in my brief, and I guess I'll throw the gauntlet down again today to the appellees, and that is, okay, if that was not motivated by retaliation, specifically by Spears 1, which was ongoing when this happened, then what motivated it? Why else would senior law enforcement officers do this kind of stuff? And again, I don't even have to meet that standard. I don't have to show that it's the most likely explanation. I have to show it's a plausible explanation that jurors could believe. And in this case, the appellees can't even offer an alternate explanation. So I would argue that that's it's an insurmountable issue, essentially, for the appellees. With respect to First Amendment retaliation, I don't think there is any other explanation. We did, of course, include a due process claim and an equal protection claim. Those are not our main claims by any chance. They're smaller, but we believe the First Amendment claim is all-encompassing. This is a pattern that goes all the way back to 2015. It has not stopped, and until my client can get relief from a court, we don't believe it will stop. And if there are no further questions, I'll be seated.
All right.
May it please the court. This case is not about altered records or about the facts of Spears 1. It's about pleading sufficiency. And there's 4 reasons why Billy Spears' complaint has not met the standard under Rule 12b-6. First, he has not stated a First Amendment retaliation claim. As pled, his claim is not ripe, he has no standing for the injury he has alleged, and it is not clearly established under the clearly established prong of qualified immunity that completing a PIP after 3 days is an adverse employment action. His due process claim fails because he has been deprived of nothing in which he has a property interest, and he has not pleaded an equal protection claim and has not been deprived of access to the courts. And if the court disagrees with those premises, he has cited no factually analogous cases to meet the clearly established prong of qualified immunity. Now, regarding the First Amendment retaliation claim, it's important to remember the injury he has pled. This is at record 284, record 285 of his complaint. The injury he alleges is not that he is on the PIP. The injury is that he has completed the PIP, but that remains in his file and might hurt him should he apply for a new job. That claim is not ripe, and he doesn't have standing to bring it because the Supreme Court and this court have held that if an injury is speculative as opposed to concrete and particularized, and if further factual development is required and the injury is not actually impending, then it's a speculative injury for Article III purposes.
Are you focusing on the fact that of the specific nature of this PIP? Would you say the same, would you make the same argument if this were a public reprimand, if this were in your view, a more significant statement in his file of some sort of misconduct on the part of the individual?
Perhaps if he were still on the PIP, but because the PIP lasted...
No, I'm not saying that, but your briefing talks about the PIP not being necessarily even an adverse, being sufficiently adverse, but some other things much more clearly adverse, discipline of a more significant nature. Would you also say those claims would not be ripe to make such a claim if that were in his file?
I'm sorry, Judge, I couldn't hear the first part of your question, Judge.
Is a more significantly adverse itemization in his file subject to the same argument you're making about ripeness?
I think it would be, and that's because the ultimate injury, and he is seeking the remedy of damages, he's not seeking the remedy of injunctive relief. And so I think that ultimately the injury is not that there is a document in his file in which he's already completed the plan, it's that in the future it might hurt him. But he's never told us what type of job he is applying for or what the qualifications of that future job might be. And if he were to be denied that future job, we wouldn't know the reason for why he did not get that future job. So I think for that reason there's a ripeness and a standing problem. But I also think that it's not clearly established for the purposes of qualified immunity, and the court has held that qualified immunity cannot be done at a high level of generality and has to be particularized to the facts of the case, that being on a PIP for 3 days and successfully completing it simply by passing a physical fitness test is clearly established. In other words, qualified immunity has to be looked at from the perspective of DPS, and he has cited no case suggesting that a reasonable DPS officer would know that placing someone on a PIP for 3 days, having them pass a fitness test, and then taking them off the PIP is clearly established as an act of First Amendment retaliation. And I also want to draw the court's attention to 2 unpublished Fifth Circuit cases, Jackson versus Honeywell and DeHart versus Baker Hughes, in which Judge Higginbotham was on the panel. And those are Title VII retaliation cases. And those cases talk about how written warnings or PIPs are not necessarily adverse employment actions, and it cites the Burlington Northern case in the Title VII retaliation context, and talks about how if a reasonable employee could continue to engage in the protected activity, then it's not necessarily an act of First Amendment retaliation. And there's also at least 3 circuits, the 7th Circuit, the 10th Circuit, and the 8th Circuit. The 10th Circuit case is at 905 F. 3rd at 1173. The 7th Circuit case is at 562 F. 3rd at 818. And the 8th Circuit case, excuse me, the 7th Circuit case, the 8th Circuit case is at 759 F. 3rd, 880, Note 2. Those are Title VII retaliation or FMLA retaliation cases. And those cases hold that being put on a PIP alone, at least in the Title VII retaliation context, is not an act of retaliation. But of course, the court doesn't necessarily need to reach that issue, and I want to address the issue of causation, which we talked about in our briefs. It's important to remember that Spears 1 was filed in April of 2015. That's at record 282. He was not placed on the PIP until 2 years later, in September of 2017. That's at record 284. And the first remotely negative piece of criticism, the first, according to his complaint, the first negative thing that happened to him wasn't until May of 2016 when he was first informed that he was unfit for duty. That's at record 283. So the first possibly actionable thing that happened did not occur until 2 years after Spears 1 was filed, and the first piece of criticism of any type didn't occur until over 1 year after Spears 1 was filed. So we think there is a temporal proximity problem with tying the allegations in Spears 2 to the allegations in Spears 1, a case ultimately in which the district court granted summary judgment on all of the constitutional claims, and then the parties stipulated to dismiss the one remaining claim under the Texas Whistleblower Act. Mr. Spears also alleges a due process and an equal protection claim. His due process claim is not properly pled because he has no property interest in his deprivation. He alleges that the defendants failed to notify him that they denied his medical waiver, and that act denied him due process. That's at record 287, note 2. But this court has held that in the public employment context, you have to have a deprivation of some type of property for the due process clause to be an actionable cause of action. So the only statute he cites, and this is Texas Government Code 411-007E, which is a statute that says an officer or employee of the department may not be discharged without just cause. But Mr. Spears has not been discharged from DPS, and according to his complaint, he still works there. So for that reason, he doesn't have a property interest, and he has cited nothing suggesting that the denial of a medical waiver is a property interest, so he has not properly stated a due process claim. Regarding his equal protection claim, and this is page 15 of the blue brief, he writes that the plaintiff's only equal protection claim arises from the facts found in paragraphs 50 and 51 of the complaint, and he directs the court's attention to Ryland versus Shapiro. Well, Ryland versus Shapiro is not an equal protection case. Ryland versus Shapiro is a case about access to the courts, which is a right that is found in the Article 4 Privileges and Immunities Clause, in the Due Process Clause, and in the First Amendment right to petition. So it's not actually an equal protection claim, but to the extent that he argues that he is deprived of the right of access to the courts, the Fifth Circuit case of Foster versus the City of Lake Jackson, that's a 23 F. 3rd at 430, and this is footnotes 7 and 8 of that case. And that case talks about how Ryland versus Shapiro is really about the right to institute suit. And Mr. Spears has now instituted suit twice, and there's no allegation that he was, of course, denied the right to file suit. He has twice, and so for that reason, there's certainly not a right of access to the courts issue, and he doesn't actually plead an equal protection claim. And the last thing that I want to talk about is the issue of qualified immunity, which I began with. The story with qualified immunity, and this is the clearly established prong of qualified immunity specifically, we think the court can simply use its discretion under Pearson versus Callahan and say that assuming regardless of whether there is any type of First Amendment or due process or equal protection violation, he has cited no cases factually analogous, particularized to the facts of the case, and not at a high level of generality to suggest that any of the defendants should be denied qualified immunity. And for example, this is at page 21 of the blue brief, and he writes, "It's long been established that public employers may not retaliate against a subordinate for exercising his First Amendment rights." But that's the type of argument that the Supreme Court has rejected, saying that it's being made at too high a level of generality. And so for that reason, we raised the issue of qualified immunity in the district court. The district court did not rule on it because it dismissed the case for us. We raised the issue again here in this court, and for that reason, the burden is on Mr. Spears to cite a factually analogous case in any of his substantive claims, First Amendment, equal protection, due process, to suggest that any of these acts are clearly established as violations of either the First Amendment, the due process, or the equal protection clause. So unless the court has any further questions, in closing, I'll simply ask the court to affirm the judgment of the district court.
All right, thank you, sir.
Pardon me. May it please the court. Essentially what the appellees are arguing is that you have to have a case on all fours where a supervising police officer did something akin to framing a subordinate police officer in order for that to be qualified immunity. The cases that we cited in our brief establish, and it is well established, that you cannot retaliate against employees for exercising First Amendment rights, filing a lawsuit, speaking out on matters of public concern. And my question would be simply as a matter of common sense, and of course looking at the Supreme Court precedent in the Fifth Circuit as well, is there any way that a reasonable police officer could go, well, there's nothing that says I can't forge documents to try to frame this subordinate of mine, and so therefore it must not be unconstitutional. That argument is just, it's not a plausible argument at all. I think any reasonable officer would know that you're not supposed, that it's clearly established you can't start retaliating against subordinates because they filed lawsuits, because they've spoken publicly, or that sort of thing. There was an interesting argument made that there's too much attenuation, that because my client was placed on the PIP 2 years after he filed Spears 1, it's too attenuated. That completely ignores the fact Spears 1 was pending. It was ongoing when this PIP was filed. And in fact, the officer who was accused of fabricating and forging documents was one of the defendants in Spears 1. So it's more than a bit of a reach to say that it's too attenuated. This guy had been sued by my client, and the next thing you know, he tampers with records in order to frame my client and make it look like he was not in compliance. Whether or not the PIP can be an adverse action, I would just direct the court to the district court's opinion. And I'm looking on pages 8 and 9 here. I'll start with the Fifth Circuit case, which says, and the case is Jackson versus Honeywell, that is from 2015. It says, written warnings and unfavorable performance reviews are not adverse employment actions where colorable grounds exist for disciplinary action or where the employee continues to engage in protected activity. However, the court looks to determine whether a challenged action is materially adverse. In other words, whether the action is, quote, harmful to the point that it could well dissuade a reasonable worker from making or supporting a retaliation claim. Let me ask you this question. If you're a police officer and you know that your senior commanders are going to forge documents and try to frame you, if you get crossways with them, if you speak out against them, if you sue them, is that not going to dissuade a reasonable worker? Clearly it is. And so I think it's under these circumstances, clearly The performance and one other thing I should add, and we lay this out in the complaint, it was not just a matter of putting my client on this performance improvement plan. The scheme was to fire him, and they had already set that ball in motion, saying that he was not in compliance with his physical requirements, and then the next step was just to force him out of DPS entirely. Is that going to dissuade a reasonable worker from exercising his First Amendment rights? Clearly, yes. Yes, it is. The question of of access to the courts, I think counsel misstates the law. It doesn't say that DPS has to actually blockade the courthouse and prevent my client from getting into the courthouse and filing something. As we just read, the issue is whether it's going to dissuade a reasonable worker, which is exactly what has happened here. They tried to frame it. Qualified immunity we've already discussed. Too high a level of generality. Again, the question is, can a reasonable police commander look at this situation and say, hey, Billy Spears just sued me, but there's nothing in the case law that says I can't frame him and forge documents in order to force him out of DPS. No reasonable police supervisor would have thought that was constitutional. And I have nothing further, Your Honor.
All right. Thanks to you both for helping us understand this case. We'll take it under advisement.